Good afternoon, everybody, and a warm welcome to our 11th session. Our topic for the day, as you know, is who can get legal aid, does it really work, and everything that you need to know to help others and yourself. I'm sure many of us in this room, I pray, are not ever going to be in a position where you need legal aid, but all of us know someone or the other whom we want to help and who will require it. It gives me great pleasure to invite our honorable speakers on the stage. One is missing, Advocate Jamshed Mistry, Advocate Lakshmi Maria Jenkins. Lakshmi, thank you so much. She's had a bad bout of not feeling well, but she's still here. Advocate Rajiv Ravi and our activist Raju Wagmare. Thank you so much, all of you, for accepting our invitation. Big hand to Jamshed Mistry. May I start by requesting Dolphy D'Souza, convener of Police Reforms Watch and our partner for this series, to welcome Mr. Advocate Jamshed Mistry with a bouquet of flowers. May I request Yogesh Sapkari, our deputy editor, to present a bouquet of flowers to Advocate Lakshmi Maria Jenkins. May I request Ashwin from Police Reforms Watch to present a bouquet to activist Raju Wagmare, please. And may I request my colleague Pankaj Raheja to present a bouquet of flowers to Advocate Rajiv Ravi. We are truly lucky to have the support of Advocate Jamshed Mistry on this program. Jamshed, of course, we pester him as a matter of right because he is on our a special invitee to our Board of Trustees, and he has really gone out of his way to put together today's session with all the ups and downs. All kinds of things happened. I'm sure many of you saw our first mailer. Nilesh Sangit was supposed to be here and he's down with dengue, and even then from his sick bed he was coordinating with Mr. Wagmare and Jamshed on the phone, and really happy that Lakshmi and Rajiv Ravi also chipped in and said these are all professionals who are devoting a lot of their personal time pro bono to help people get legal aid. And I think we need to hear from them because it is somebody who appears on behalf of you in a court of law who is able to tell you how the system works and whether it works at all. You know the way our program rolls out. It gives me great pleasure to introduce our speakers. After all four speakers have told us a bit about the subject, we then have a Q&A session, and you know that we have shifted to written questions, so all of you have those slips with you, so please give your questions in writing. Remember to switch off your mobile phones and also fill up your feedback forms. I now introduce Advocate Jamshed Mistry. He appears as a counsel in the Supreme Court and in various high courts all over India. He is a senior counsel with the Central Government Panel for Advocates of the Bombay High Court. He also works actively in social and medico-legal causes like the rights of disabled people, beach safety, the Goa Action Plan, setting up of hawking zones, issues like surrogacy, and he's always trying to explore and research new areas, new legal questions which haven't been asked, sometimes in countries other than India. He has assisted the court as a amicus curiae in a large number of cases. In fact, I think he's been appointed amicus curiae in the largest number of cases in the Bombay High Court for sure. He was invited to assist the Goa Law Commission to set up the first Institutional International Arbitration Center at Goa. He's an associate member of the Canadian Bar Association and does a lot of work related to the Canadian business chambers as well as people who have had to deal with that country even in films and media. He's a special invitee, like I said, to Moneylife Foundation's Board of Trustees, and he's the founder of internationallegalalliance.com, which is a global network of lawyers. He is associated with a whole lot of international law firms in UK and US, and I'm not going to get into details there because it's going to embarrass him. He's here to talk about legal aid. Advocate Lakshmi Maria Jenkins specializes in negotiations and transactions relating to intellectual property rights, media and entertainment, including trademark, copyright, patent and design registrations. She also handles civil and criminal litigation in the area of corporate law, company law, consumer issues, banking and maritime laws. In the context of her talk today, she appears as a lawyer for those requiring legal aid and can give us a first-hand perspective on what happens there. Advocate Rajiv Ravi is an LLM in Constitutional and Administrative Law from the National Law School or National Law University. He has appeared before various courts, arbitral tribunals and quasi-judicial forums. He provides advisory and litigation support services in respect of commercial disputes, in indirect tax, excise, customs, service tax and foreign aid, trade, as well as devoting time to legal aid. Activist Raju Wagmare has the most formidable biodata that I have seen. And Mr. Wagmare, forgive me, I'm going to cut it short because it's really so long. He's an activist working for the betterment of disabled people. He has a master's degree in social work from the Tata Institute of Social Sciences. He has a vast body of work on issues relating to people with disabilities, mental health, right to education and other issues. He's been on several official bodies that have helped the government draft policies for the disabled. He has also been involved in public interest litigation for their rights. He regularly conducts workshops on disability rights and works towards addressing issues of disabled people at various forums. I now hand over the mic to Advocate Jenkins.
A very good evening to one and all. I am going to introduce the topic of legal aid services from a history geography perspective. I'm going to give you a little bit of a background as to how legal aid has developed over the years, not only in India but on the international, the international background of it. Why has it caught up in a manner that it has, and what is the tentative area that it may be able to cover in the future, right? So let's get started. We see on the screen, legal aid effectively is supposed to cover. Now, when I say supposed to cover, is that it may not really cover it as per the statutory provisions, but this is what legal aid services is supposed to cover. It's supposed to be giving free legal services to the poor and the needy. When the idea of legal aid started first, the advocates who used to give out legal aid were known as the advocates for the poor. There's this long known nobility which has always been associated with the legal fraternity. And therefore, people like to become advocates, because in the earlier days, or maybe in the ancient days, there was no fixed fee that the litigant would pay his attorney or his advocate. It was either gratis, or it was a situation where he would give his attorney or his advocate as much as he deemed fit or much as he could afford. Therefore, the entire scope and ambit of legal aid depended upon the morality of the advocates, the morality of the fraternity at that time, and moreover as to what the government or the empire or the reigning monarch at that point of time thought. There was no statutory rule as to what legal aid was, what it's supposed to be, and how was it supposed to be dealt with. So from the earliest times, this is what we've gathered, that legal aid is supposed to be giving free legal services to the poor and the needy, to those who cannot afford the services of a lawyer, for the conduct of a case or a legal proceedings before any court, any tribunal, or before any authority. Now, if we look at, like I said, we look at the history of legal aid. Legal aid started somewhere in the early 1850s in France, wherein the reigning monarch at the time, he happened to be a God-fearing chap, So he decided that we should do something for the poor. And the idea of doing something for the poor stemmed from that entire, the history of the revolutions, wherein they thought that if they don't do something for the poor, we are going to have another revolution. So the idea of doing something for the poor also stems from the fact that they want to protect their own, situation, as in they want to continue as monarchs or whatever. But in that entire idea of doing something for the poor, there were many French advocates who formed organizations. And these organizations, not only for the bar, not only in other areas, but these people came forward, and whether it was appreciated by the monarch at the time or not, they went out of their way and took on matters which were pro bono, in the sense were not paid for, or in certain instances found sponsors for those people who could not afford legal fees. So if I was an advocate and if I knew a friend of mine who was quite a rich chap, or somebody who had the means, so I would go up to my friend and say, there is so and so person cannot afford legal fees, can you please do the needful? Can you please foot the bill? So that is the sort of thing that they would do. Over the years, now if you see, why I provided this timeline is that so that you realize how long it has taken the idea of legal aid and legal aid services to actually catch up in the world. You see, 1951 we actually started something in France. Along the same time, in the 1851 we started France. 1800s, there is this movement which starts in the US. Again, they are known as poverty lawyers. You see, none of them are known as advocates providing legal aid services. They are known as advocates for the poor, the poverty lawyers. So these lawyers helped in the US, they helped people realize their rights and improve their situation. So whichever way the government functioned, whatever were the statutes, whatever were the laws, they would just help them pick and choose, like, okay, fine, this is the provision. How in this provision are you going to get what you deserve? They are not doing something extraordinary. They are not pushing the government. They are not lobbying for the rights of the underdog. What they are doing is they are telling the people that this is the law. In these facts and circumstances, how do you find whatever is advantageous to you? Right? Then we go on to 1876, the first legal aid society established in New York. Now, surprisingly, till date, there is no statutory law in place in the US for taking on legal aid. There is an organization, there is a corporation of the state which provides legal aid services and which provides insurance. In case you have a situation and in case you think you're going to get into a litigation for some reason, they provide you insurance for litigation as well. But there is no statute which says that this is the statute, under this statute, people below a particular earning income need to get legal aid. And that is very surprising, because this makes it not only compulsory upon the advocates in the US, but it is a matter of pride to stand up and say, yes, my firm does so many matters on pro bono a year. So they have a bit of a ratio, like, for every 10 matters you do, I will take on 2 or 3 matters pro bono. So this is the kind of thing. So because there is no statutory limitation, at least that's the way they like to put it across. In our country, obviously, we say that it's better to have a statute because it helps people. We know what the rights of the people are. We know what the crystallized law is. But in the US, they don't, because of the absence of a crystallized statute. They are beholden by their practicing undertakings that they will take X number of matters per year, or the firm which has a turnover of X amount will do so much of pro bono work per year. And that is just not the firm, it is every advocate who works in that particular firm needs to do X amount of free legal aid work. We go on to 1964, wherein the Economic Opportunity Act was passed if you remember, 1964 is that disastrous year wherein JFK was shot and his successor, the Vice President J.B. Lyndon, became the president at that time, and this is the same year in which the act was passed, the statute was passed, giving the colored population of America freedom as equivalent to the white population. So that was a culmination of ladies being given the right to vote, the black population or the colored population, the African Americans, getting the freedom, the same kind of freedoms as the white population would get, and all that was all because of President Lyndon at the time. So he also came up with something called the Economic Opportunity Act. So people with different economic strata, from different economic strata, would get the same opportunities in law and in life. So that was part of this act. Then 1945 is obviously the close of the Second World War, and that is a point wherein the realization of legal aid services for people en masse became a factor which was realized by many, because obviously we see at the end of the Second World War, we see a number of countries which are hammered down by the losses and the destruction of the Second World War, and people need to make their claims, people need to move against the state, people need to get their act together, and obviously they don't have the money or the funds to do so. So people realize that yes, there has to be some situation of legal aid, there has to be something of legal aid services to be provided by the people. But if we look lower, we see where the British action starts. You see, if you look at 1851, France, and then we come down to 1945, 1948, 1949, you can see there is almost, or I'm not saying exactly, but almost 100 years between the realization for legal aid services in the world and the time that the British actually took it up, not only in the British Empire, not in the British state, but also in the Commonwealth nations. I know this is getting a little bit boring, but this brings us to what the Indian scenario is and when realization started in India. Now, when we go, 48, now these are a little bit tricky because they relate to the Indian scenario. 48 is when the Rushcliffe Committee, the Labour Party, decided to go into and prepare a paper on what is legal aid services, what is the scope, the ambit, who benefits, who does not benefit, how do we have the guidelines set out, who are the people who would be who would be enabled in a way to ask for these legal aid services, where do they go. So this entire study, like how we have our law commission reports, this is the way they had prepared. Rushcliffe was one of the judges who was in charge of making the committee report. 1949, of course, the British Legal Aid and Advice Act comes into picture based on the Rushcliffe Committee. Now we come to the Indian scenario. Now, if we look through history, through the Vedic times, the Muslim times, the Hindu, and especially the British periods, we've had a consistent character of legal aid to the poor and the downtrodden being given. Even if you see our ancient Hindu culture in this, in the Mahabharata, as we call the before partition and during the Ashoka times. So there is this color of legal aid which has been given to the poor, the needy, and the downtrodden consistently. Whether it was by the benefit given by the king, whether it was a sort of a protection which was exhibited by the person in power, there is this consistent help which has always been given to those who could not afford. 1908 is when the civil procedure came in. Now, if we look at the wordings of Order 33, Order 33 is one particular provision of the Civil Procedure Code, which provides that an indigent person, that means a person who is poor, a person who cannot afford. An indigent person, if he is not possessed of sufficient means, so if he doesn't have the means to, and what are the means that they are looking for? Now, these words are on the screen for a particular reason. So, what are the means that they are looking for? They are looking for the means that enable him to pay fees prescribed by law for plaint in such suit. For example, you want to go and file a suit in a court. Now, you know that when you file a suit in a court, you need to pay something which is called as court fees. So, if a person is coming from such an economic background that he cannot afford to pay the fees in a court, therefore this person needs to make an application. So, if he doesn't have the monies to pay in the terms of court fees, so he makes an application to the court, and the court will then hear the application, see what are his proofs, his documentary proofs, and then decide on whether or not he should be given an exemption. So this happens before the filing of a suit. Alright. Then of course we are looking at 1924 Legal Aid Society, wherein obviously the inspiration is what has happened in the First World War, what has happened in France, what has happened in Britain. 49, again following the Rushcliffe Committee, we have the exemplary personalities of Justice Bhagwati, and of course later on Justice Iyer. These are judges who have admitted writ petitions, who have admitted public interest litigations on a postcard. Like for example, if you were an aggrieved citizen and you would have written to the courts on a postcard saying that, you know, this is my problem, this is the problem, these are the people who are suffering. So these are judges of the Supreme Court, of course retired, who have admitted public interest litigations, who have admitted writ petitions on the basis of these postcards. So this is the era of judicial activism as it has started. Now, taking this forward, we have Article 14, which guarantee of the Constitution of India, of course, which guarantees equality before the law and the equal protection of the law. We have Article 21 of the Constitution of India, which guarantees the right to life and dignity subject to due procedure. Now, what does this mean? This means, in very simple terms, that irrespective of who you are, any citizen of India or any person who claims the protection of the laws of India in whichever manner, maybe you've been living here as an expatriate for 10 years, okay, but if you claim the protection of the laws of India, this is what the Constitution of India guarantees to you. One is equal protection before the law. Second is the equal protection of the laws. Third is the right to life and dignity. So without due procedure, without the proper application of laws, your right to life, your right to dignity cannot be taken away. This means that irrespective of what your disability is, whether economic or otherwise, this is what the Constitution guarantees you. Now, when you see Article 22, it makes a very interesting reading because this provides a further protection to anybody who has been arrested. It says that he shall not be denied the right to consult and be defended by a legal practitioner of his choice. Now, this is something that the legal aid services in this country till today does not provide you, but still, you may have the right to go to legal aid services, you may have the right to make that application, you may have the right to get legal aid, you may even be given legal aid. But you may have one of the stalwarts of this nation defending your petition or prosecuting your petition, but you do not get to choose who is the lawyer who will be representing you. 39A of the Constitution of India guarantees equal justice and free legal aid. Now, this also forms a directive principle of state policy. Every state is supposed to ensure that every person, whatever may be his background, whatever may be his social strata, whatever may be his economic situation gets equal justice and free legal aid. Now, the interesting portion is that if you've seen the timelines, and if you've noticed that once in 10 years something happens, once in 20 years something happens, once in 100 years something happens, and that's the way legal aid has progressed. It has progressed in spurts. It has progressed in a situation where people have woken up, the populations have woken up in decades. Once in a decade something happens. And therefore there is this staggered method of progression which we see. We also see, I have put one point very clearly, is that law colleges have provided a lot of paralegal assistance through legal aid clinics and street legal aid. There are many colleges, whether it is Delhi University, whether it is Government Law College, whether it is KC Law College, whether it is any law colleges, national law schools, you see, they have these legal aid clinics wherein the students are in a situation to sit with those maybe from the slums, maybe from a situation where they cannot afford lawyers. So these law students sit with these people, give them a bit of a guidance as to what is to be done, what is not to be done. Obviously they have guidance from their professors and things like that, but this has got a long way in shaking up the system and making people realize that over the years it is not sufficient to have a legal student there guiding them. You need more than just a legal student guiding people in their need for justice. Then in 1987, now we see what we know today as the Legal Services Authorities Act. Now what is covered under the Legal Services Authorities Act? We have the National Legal Services Authority, NALSA otherwise known. At the center, this is the authority that makes the laws. This is the authority that lays down the guidelines for legal aid services across the country. We have the State Legal Services Authority, state level. They carry out the guidelines, they carry out the POA, they carry out the methodology that NALSA has put down. We have the Taluka Legal Services Committees to coordinate the legal services in the Taluka and to organize Lok Adalats. We have the Supreme Court Legal Aid Services, we have the High Court Legal Services, we have the District Legal Services. Now, it is very easy to say that there are too many of these organizations and there are too many cooks in the kitchen. But the point is that these organizations, they have a different ambit, they have a different scope. Like for example, if you go to the National Aid Services Committee, they would look at it from an entire nationwide perspective. If you go to the Supreme Court Legal Aid Services, you would get services restricted to the Supreme Court. So in that way, each one of the committees, each one of the organizations have a different ambit to look at. The last thing that I would like to show you is something that is catching hold of the news a lot. This is also comprised within the Legal Aid Services Act, but this is what I'm talking about is the Lok Adalat. This is something that any person who looks for legal aid, if you don't have the way and the means and you definitely do not find a good representative through the legal aid services, you can opt for the Lok Adalat. Now what is a Lok Adalat? A Lok Adalat is a people's court. An award passed by the Lok Adalat is as good as a decree. It's been held countless times in the Supreme Court. It's especially helpful in pre-litigative phase. Like for example, if you have a case and if you think that I really don't want to fight this for so long, you can tell the judge that please send it to the Lok Adalat. We will try and settle disputes amicably between ourselves. Now, what are the advantages of doing this? There is no court fee involved. Even if the case is already filed in a regular court, your court fees are paid. If you settle the dispute, you get your court fees back. Second is there is no strict application of the procedural laws. And the evidence while assessing in the merits of the claim by Lok Adalat. So if you're talking to the judge will not look at it from the strict perspective of the laws. He will consider what you are saying over and above what is there in your paperwork. Next. Okay, then the important part is the later portion of part 2. The parties can interact directly with the judge. You don't need a lawyer there. Even if your lawyer is there, if you want to say something, you want to argue your own case, you can always tell the lawyer, I want to argue my own case, you can argue your own case. Okay. Next is disputes can be brought before the Lok Adalat before you actually go to court. For example, you can leave the litigation process for the second portion. You can say, I want to go to Lok Adalat, try my hand at a settlement. If it works, it works. I will solve the problem here and go home. I don't need to hang around here and waste another 10-15 years of my life. So that is a possibility. If it doesn't work, you can always go back to litigation. Okay. And lastly, the decision of the Lok Adalat is binding on parties to the dispute. There is no appeal possible from a Lok Adalat order, because all orders which are passed by consent and by settlement, you can't appeal them. So once you are settled in the Lok Adalat, your matter is closed for good. Okay? Thank you very much.